Thank you, Last Count Corla. Yeah, this is incredibly sharp.
No, sorry, I beg your pardon.
Yeah, this is incredibly sharp practice on the part of the government. It really makes a mockery of any sort of proper oversight of legislation. We had a briefing on Monday from officials about these 48 pages of amendments, very, very substantial amendments in the areas of planning, affecting the rights of people to access justice through judicial reviews, and affecting what is, I think, broadly a good objective in terms of short-term lettings, but as others have said before me, where the objective and the actual translation into legislation may not be the same thing, and everything of that sort needs to be scrutinised properly. And I had to ask at that briefing, could we have an explanatory memorandum to actually, as we do with all legislation, we get an explanatory memorandum to try and translate what is often, and in this case is, quite dense legislative language into relatively plain English, so we can understand what we're actually looking at, what we're actually voting on. And I got this explanatory memorandum on these 48 pages of amendments from the government, last-minute amendments, in a bill that is being guillotined so that we won't have time, in reality, to look at and scrutinise properly at 2 minutes to 9 this morning. 2 minutes before this debate started. I mean, that is just a joke. It's an absolute joke. It's the government laughing at the opposition, showing utter contempt for the legislative process, for democracy, and for the public. And these amendments that the government are bringing forward, so far outside the scope of the original bill that we started in second stage to deal with, if we brought amendments, anything even remotely similar in terms of being outside the scope of a bill, we would just be laughed out of court. They would be ruled out of order, they wouldn't be allowed. But the government can do it by putting forward this motion and ramming it through, and then guillotining the bill later, so we don't have proper time to scrutinise them. But the actual substantial amendments, which are of particular concern, relate to planning matters and to the question of judicial reviews. And these are very, very important issues indeed, and I just wonder at the timing of them. I mean, to my mind, I suspect they result from the lobbying of the private offshore wind industry. That's what I think. I think they've lobbied you to do this, and that's why it's being done. So that they can get flexibility in terms of planning applications for offshore wind, industrial wind turbines. And essentially what the amendments amount to is, from a planning sort of point of view, from the public point of view, a pig in a poke, buying a pig in a poke, because they will give them the flexibility to apply for one development, but then for the development that they actually develop to be a different development. That's what the flexibility amounts to. So the height of the wind turbines can change, the design of the wind turbines can change. Now the government will say, oh, there's safeguards and they have to prove that it's, you know, they have to show the different options and so on and so forth. But I mean, all of that should be subject to serious scrutiny. But in actuality, we are dealing with a very, very serious matter, which is the ability of private developers, because that's what we're talking about here, probably most particularly on these legacy projects, these relevant projects as they're talked about, for offshore industrial wind turbines to be able to put in a planning application where the public have to sort of respond to a particular type of planning application, but then what actually is developed later may be something completely different. And then to limit the ability of people to take judicial reviews against developments that are being applied for, that may affect them or affect the environment, and so on. So that is really unacceptable. I'm sure the government doesn't really give a hoot that we think it's unacceptable. They're just laughing. That's what they do at this time of year. No, but I think in a more broad sense, the government is laughing. They're trying to make fools of people, as they do every single year at this time of year as we head towards the summer recess. They barrel through a deluge of legislation, they guillotine it to get through, smuggle in matters that, if they were scrutinised properly, could be of very, very serious import and concern to people, but we really will not have the chance, and the public will have no chance whatsoever to have any look into these things, to express any opinion on them, because it's done and dusted before they get sight of them. And that is pretty outrageous. So for that reason, we've absolutely no choice but to vote against this motion. Because later, we have 2.5 hours to scrutinise this stuff later. We've got the substitute consent issues. Then we have the short-term letting stuff, the judicial review stuff, and the maritime area planning stuff. Absolutely no chance of any of that being scrutinised properly at committee remaining stages. So it's pretty disgraceful, it's totally undemocratic, and it shows contempt for the public in this House.